Before we get started, everybody, and I introduce our speakers. Tonight's topic is make it legal. Applying the law on social media. We have two fantastic speakers here with actual law degrees. A couple of reminders when we get into the Q&A session. If you have questions, please be sure to ask them in a sort of a more generalized term. While every legal situation is distinct and unique, please don't drag us through all the specifics. If you have a specific question, you can always grab one of our panelists after the event, okay? We really encourage you to do that. A couple of reminders. We have historically held our events here at General Assembly. For the next two events this year, and our last two events of this year in October and November, we will be at Blank Spaces, which is right up the street, and across the street from one of the public parking garages. So please be sure to make note of that. We'll, of course, remind everybody for the next couple of events. The next event will be about video, and the event after that is going to be a Best of LA social media contest. So if you have done a great campaign or a great integrated campaign using social media, we really encourage you guys to apply. We'll be sending that information out in the next couple of minutes, or literally in 30 seconds. Literally, go. Everything's immediate. Okay, literally. Yes, Jeff, please. Yes, thank you. Thank you to our sponsors tonight, Fruit Bliss, who's been a sponsor of ours for the last couple of years. Can we get a round of applause for Fruit Bliss? Yes. And Giant Kombucha, which everyone was raving about. So thank you, Giant Kombucha. Round of applause. Okay, so I'm going to introduce you guys, and then we're doing a little bit different format tonight. We're going to give each of the speakers about 15 minutes to give you a broad overview of what they learned in 4 years of law school. And then I will ask them a couple of questions, and then we're going to turn it over to you guys for Q&A. So my first speaker is Robert Freund. Did I say it right? Yes. Okay. So Robert is an experienced litigator and advisor, focusing on false advertising litigation and compliance with an emphasis on social media and marketing issues. Before opening his own firm, he's an entrepreneur as well. He honed his legal skills at Greenberg Traurig, which is where he met Rebecca, I think, right? Did you guys work together? Okay. And Greenberg Traurig is one of the largest and most complex commercial litigation companies, law firms in the country. He went to law school at UC Davis and clerked for the Consumer Protection Unit of the Alameda County District Attorney's Office, working on civil and criminal cases for fraud, deceptive advertising, and anti-competitive practices and other economic crimes. So you are dealing with the man who has been on both sides of the fence, ladies and gentlemen, Robert Freund. Have a seat over here for just 1 second. Thank you, Robert. And Ms. Rebecca Guyon, who also works at Greenberg Traurig and represents a variety of clients in business and commercial disputes, has significant experience advising companies in complex privacy and intellectual property matters, including trademarks, trade names, and brand management issues, crisis management and data breach responses, and discovery strategy for cutting-edge data platforms. Did you hear that? Mm-hmm. So not only is she a lawyer, but she gets the numbers too. Okay. Ms. Guyon, Rebecca, have a seat. Thank you for joining us. So I'm going to let Rebecca get started. First, let me pull up this. Here. Can you help me manage this? I can't do it all at once. Here we go. Okay, Robert, you're going to go first. You're up. No, I mean, no. Technical difficulties. Should be. Perfect. Let me do this. Sorry, guys. Chris, stand for it. Your name.
I'm saving that for October.
All right. Okay, so because I've only got 15 minutes, this is going to be kind of a rough overview. The idea is to help you understand compliance if you're running a social media campaign, especially one that involves using influencers to market whatever it is that you're marketing. So apologies if this jumps around a little bit or seems kind of disjointed. I just want to get the information out, and then we can get into some more detail during the Q&A. So compliance, who is responsible and who do you have to worry about? At the federal level, the Federal Trade Commission is charged with making sure that advertising is not misleading and not deceptive. At the state level, most states have unfair deceptive acts and practices laws that sort of mirror the FTC Act. So that's the state regulatory authority to enforce these compliance rules. And then you have to worry about private litigants too, which means people who aren't the government suing you. So the Lanham Act is a federal statute that allows people and companies to sue for false advertising, and California has its own set of laws that allows that too. As I mentioned, the FTC is in charge of making sure that advertising is truthful, not misleading, and claims that you make are adequately substantiated. We'll get into what that means in a minute. So a big question that comes up a lot is who is liable? Is it the person who makes the website? Is it an agency that you hire? Is it an influencer themselves? And the answer is absolutely everybody is potentially liable for violating the FTC, all up and down the chain. If you touch the ad at all, you're potentially on the hook for screwing up. So native advertising and social media. Native advertising just means ads that don't really look like ads or are supposed to appear like they're just organic content, but is actually selling something. And the concept of native advertising existed before influencers became a thing. And so the rules covering influencer advertising and native advertising there's a lot of overlap. And so influencer marketing is sort of a subset within native. The FTC has guidelines that are publicly available, and they try to write it in a way that every man can understand without getting too bored. And I think they do a pretty good job of it, but there's a lot of information scattered over the website, so it's kind of hard to piece it all together yourself. And they also have specific guides with regards to testimonials and influencer marketing and that sort of thing. And we'll go over some of the more famous recent FTC cases. That's basically what I just said and where to find the info. Right, so what we're going to try to cover is whether something that you're doing in social is an ad that's subject to these rules, and how to make consumers understand, how to make sure you're in compliance with what consumers see, basically, and the sorts of disclosures that you need to make and why. So, is something advertising? Pretty much anything that you do commercially in connection with promoting a brand or a product or something like that is going to be advertising. Some things that people might think are advertising aren't actually advertising for, as far as the FTC cares. Things like product placement in a movie, that doesn't require disclosure. You're not actually making any sort of endorsement specifically about a product. And there's no real risk of confusion if the public looks at it which is really what the FTC is concerned about. Everything boils down to, does this person know that they're being advertised to? So if you watch American Idol and you see all the judges have Coca-Cola cups in front of them, pretty much everybody knows that's not a coincidence and that they didn't all just buy Coca-Cola because they like it. So there's not really a risk of anybody getting deceived by that. Same thing with general interest articles. If a travel blogger just writes about 10 great hotels and they're not getting paid and they just happen to list a hotel they like, there's no problem with that. And the same can be true with celebrity use of products. Like if Michael Jordan is in a Nike commercial for Air Jordans, no one is going to think that it's a coincidence. There's no risk of deception there. But pretty much everything else is, and it's always better to be safe than sorry, which is something every lawyer will say a million times. So determining whether a consumer knows what you're doing is advertising. Context is king. You just have to use common sense and think about, is the person seeing this advertisement going to recognize that it's an ad? And it's fact specific, and you kind of just have to use your judgment. And these are some examples that kind of could go either way. And I think a good policy is if you're confused as to whether what you're doing is advertising and you might need to make a disclosure, then you probably should err on the side of caution. For influencers, the answer is almost always no, unless there is a disclosure, which is why this is such a hot area. I mean, I see it literally every day, not even trying to find this stuff, just people I happen to follow, even if I don't think of them necessarily as influencers, will run Instagram stories talking about a tea or a skin cream or a gym or some subscription box that they love. And if they're not saying, you know, this was sent to me in exchange for me doing this, then that's violating the FTC Act and possibly other laws as well. And disclosures need to be made so that people understand that there's a connection there. In terms of native advertising that's not influencer marketing, like if you give a review of a hotel on your travel blog, but you received a free night there, you have to make sure that people know that and that you're not just writing an opinion piece because you like the hotel. So that's the sort of thing where we were talking about native advertising outside the influencer context. I know I'm going fast through this, but trying to get into 15 minutes here. So this was an example that the FTC took a look at in terms of native advertising. This company, Taboola, if you pay them, they will place these sort of promoted stories underneath other articles online. And the FTC thought this was not good enough, that in the top right corner it said sponsored links by Taboola, right. Because somebody just looking at this might think, oh, these are other stories that are sort of related to what I was looking at, and here's like a Bloomberg News piece maybe. What they wanted Taboola to change it to say was, instead of around the web, in bigger font, paid content, and ideally there would be a disclosure about who is paying for which link to be put there so that nobody's spending time being advertised to without realizing it. Claims you can make in terms of native and influencer advertising, it has to be true, and an influencer cannot make any claim that the company could not make itself, and everything has to be supported. And the support that you have to have ready can vary by industry. If you're in the supplement industry or the pharmaceutical drug industry, there's a lot more substantiation required with scientific evidence and that sort of thing. But basically, if you can't point to something that backs it up and you're making a claim about your product, then you're setting yourself up for getting in trouble. The one example that the FTC focused on a bit was before and after pictures for weight loss supplements. If you have one person that lost 40 pounds in 2 weeks, it's not enough to just say, results not typical. You have to actually say what the typical result is beneath that and explain to people. So yeah, results may vary is not enough anymore. Other things you need to disclose, any material connection between what you're selling and who is doing the advertisement. So it's not necessarily just that this influencer got a product for free or is being paid to run an ad. If you are an employee of a company, for example, there was an FTC case involving PlayStation Vita, I think was the console. And PlayStation employees were tweeting about how great the Vita is without disclosing that they worked there. So that's the kind of material connection that the FTC cares about. Or if you're a family member of the company, or anything that could potentially influence your opinion of the product that somebody might want to know about, that would affect their decision to trust your review. We can get into examples in a bit of, the payment doesn't have to be direct, it could be even after the fact. If you give a favorable review and then somebody sends you product and there's sort of an implication that you continue to review, or give us 5 stars and you'll get a discount, that sort of thing. Anything that you can think of, basically, that could potentially affect someone's decision to trust a review or an endorsement, you need to have a disclosure there explaining it to people. So this is an example that comes from the FTC. So if you have an advertisement with a testimonial talking about how great these chia seeds are, the person reviewing it is actually part of the company, that would have to be disclosed. These are also examples that the FTC gave for what is not okay in the context of Twitter and Facebook. So this Julie Stars person is talking about shooting a movie. They said they had to lose 30 pounds in 6 weeks. They say the typical loss is 1 to 2 pounds a week. That part's okay. The issue was whether thanks to the company and then hashtag Spawn was a good enough disclosure. And the FTC's position is that it's not, because Spawn is ambiguous. The word sponsored's okay. The abbreviation Spawn is not. I think savvy people would understand what that means, but they want you to take the position of, your grandma's on Twitter for the first time, or maybe your grandma's really technically proficient, I don't know. But you want to make sure that that person can clearly understand that this is a commercial. And so Spawn isn't, and you also don't know whether this Julie Stars person was given the pills for free or whether they're part of the company or what. The same for the second example. The bit.ly link there, the idea was that that link directs you to fuller disclosures. Well, that doesn't really get you off the hook, because the FTC doesn't want anybody to have to click outside the ad itself to find the disclosure. It has to be right there and unavoidable, basically. And so even putting the word disclosures in the bit.ly link is not enough either. They want it all in the tweet, if at all possible, or hashtag sponsored or hashtag ad, or they have a list of hashtags they think are okay. So the summary of what makes a good disclosure as far as the law is concerned: prominence, presentation, placement, and proximity. And it's basically what I said about making it unavoidable and unmissable, and right there in the ad, whatever the connection is has to be disclosed there. Right, so hashtag ad, hashtag sponsored, hashtag contest, those are all okay. Just hashtagging the name of the company is not enough. Just tagging a company in a post is not enough. And it varies based on the platform that you're using. Videos need to have an audio component in case somebody's just sort of absentmindedly listening while they're doing something else. They want the disclosure repeated throughout the video. If it's a 10-minute YouTube video, maybe every 3 minutes or something like that. It's not really a bright line rule of what every single post has to have, but that's generally the guideline that they want. Let's see, did I already talk about this? Yeah, even if use of free products still needs to be disclosed, especially if it was in exchange for some kind of review. So this was a recent example of the FTC going after Warner Brothers. Warner Brothers released a game based on Lord of the Rings and sent it to this guy, PewDiePie, who I'm sure most of you are familiar with. And they gave it to him to review and paid him to do it. And obviously nobody told PewDiePie what disclosures are required. So there wasn't a disclosure in the video itself. He didn't make any mention of the fact that he was reviewing it for Warner Brothers. But if you clicked more on this YouTube description and scrolled all the way down, He says, down at the bottom, this video is sponsored. No one reads this anyway. What are you doing down here? The FTC, the FTC really didn't like that at all. So Warner Brothers, they entered a settlement with Warner Brothers where Warner Brothers had to agree to, there wasn't any financial penalty. There would have been if they didn't agree to a settlement, but a lot of the times the way the FTC settlements work is it's injunctive relief. You agree not to do it again. You agree to have a new policy in place, and it's basically public shaming, which is what happened to Warner Brothers here. Sort of similar thing happened with Lord & Taylor. They had released this paisley dress that they really wanted to promote on social media. And so what they did was they paid 50 different influencers a certain amount of money to post photos of themselves in the dress. And they also had this publication called Nylon run an ad about it without disclosing that it was sponsored by Lord & Taylor. And there were no disclosures on the part of the influencers either. So this was an example of one of the posts. Did they have a hashtag? I think they just tagged Lord & Taylor and used the hashtag Design Lab, which is the arm that produced this dress in the first place. So this was another FTC enforcement action that ended in a settlement. And Lord & Taylor had to remove all of these ads and promise they would never do it again and that sort of thing. How am I doing on time, by the way?
A couple more minutes.
All right. Well, Cole Haan did the same sort of thing. This was running a sweepstakes, which is its own can of worms. The idea was if you hashtag Wandering Soul with a picture of a shoe you bought from Cole Haan, then you're entered to win $1,000. That's the kind of thing that needs a disclosure. There wasn't a disclosure, and so there's the same kind of result. This one was against a company that took the game Counter-Strike and molded the online transactions into its own sort of lottery game. I play video games, and that whole idea is confusing to me. But anyway, these people were running ads all over social media about how great this game is without disclosing that they were the owners of the company, and they paid other gamers, I should say, to post about the game. And so they had to settle with the FTC also. Switching gears a bit, consumer testimonials. People a lot of times ask, well, if I pay someone for reviews, or if somebody makes a review that's inaccurate, where's the liability? What are the rules for that sort of thing? If a customer just leaves a review that's truthful, then, or even if it's not truthful, a lot of times there's not going to be liability for the company. But if you take a customer review and then retweet it or put it in your own ad or something like that, then that becomes a representation of the company. And so that becomes subject to all the same rules that we talked about before. So if one consumer has a great experience with a product that most people wouldn't have or that doesn't really make sense, and then you adopt that as your own promotion of the product or service or whatever, that's subject to the same rules and the same potential liability. So this is an example of that with the chia seeds again. A personal blog writing about it, not an endorsement if they didn't get it for free or anything like that. If the company then uses it in their advertising, then the statements are attributed to the company. The FTC has well, I don't know if it's nice, a user-friendly list of do's and don'ts. This is, the real benefit of this is it's something to include in contracts if you're a brand or an agency that's doing work with influencers. You should have in your agreement, you should provide them with the list of do's and don'ts, have them agree that they've read it and will comply with it. And we can talk about ways to sort of limit your liability for what influencers and user-generated content and that sort of thing. But this is just a sort of overview of what the FTC has put out that's helpful to give to influencers that you might consider working with. Right. People want to ask about, well, what can I do if people post reviews that violate the law? There's the Consumer Review Fairness Act doesn't let you sort of, you can't really put a gag order on people. You can't have people agree that they won't give negative reviews, but it also allows you control over things that are libelous or slanderous or illegal or otherwise, vulgar, obscene, that sort of thing. And we can talk about that if you have questions. To wrap up, I mentioned that the FTC settlements haven't involved any financial penalties, so people a lot of times will say, well, what's the risk then? Like, are they really going to go after me for this when they go after Warner Brothers and it doesn't seem like anything really happened? Well, the FTC has been going after influencers individually much more frequently than they have before in the past year or so. And it's a signal to potential competitors who might want to bring private lawsuits where that's the only reason people bring private lawsuits is to recover money. So the threat of financial exposure in the private sector is a very real thing, and just because the FTC has been soft on people so far, it doesn't mean that they won't in the future. And if they wanted to, the civil penalty for an FTC violation of any of these rules, it used to be $11,000 per violation, then it was $16,000. Now it's $40,000 per violation per day. So if you could theoretically have an Instagram story that costs you $40,000, well, I guess the story is 24 hours, but a post that costs you $40,000 a day, if the FTC really wanted to do that, it could happen. All right.
Thank you, Robert.
Give me a second to pull up Rebecca's prezo. Thanks for joining us, Rebecca. So I still, after all these years using technology, feel like it's so magical when something works. Thank you, Rebecca.
Hi, I'm Rebecca Guyon. Thanks for having me here tonight. So I'm going to talk about just one area of the law that you have probably heard of. It's called the California Consumer Privacy Act, and it goes into effect on January 1st, 2020. But if you are not already compliant with the CCPA, you need to be compliant right now, because the law is very broad in what it governs, and it does not start applying to the data and personal information that you collect on January 1st of next year. It already applies to the data that you have that goes 1 year back from January 1st of 2020. In other words, January 1st, 2019 on, all of that data is subject to the CCPA. I'm going to, at CCPA, California Consumer Privacy Act. Lawyers always use acronyms, so if I say something that doesn't make sense, just ask me afterwards. I'll unpack for you what that means. It's an extremely broad statute. There's actually a provision in the statute that says if there's a question in the interpretation, it is meant to have a broader interpretation than you would expect. The law was hastily enacted to avoid a more stringent, if you can imagine, ballot initiative that the California legislature would not have been able to amend. So that to say, it was a law that was quickly enacted, which usually does not go well when legislatures do things very fast. So there are a lot of criticisms and inconsistencies within the law. Some of those have been fixed in the last year with the legislature amending the law in a lot of ways, but in other ways there is still some room for vagueness, and I'll talk about that. There are 5 basic rights in the CCPA for all California residents. They have a right to notice of the personal information that is collected from them at the time that a company collects it or before. They have a right to disclosure of the personal information that a company has collected and copies of the specific personal information that a company has collected. They have a right to disclosure of the categories of personal information that a company has sold or otherwise disclosed from him or her. They have a right to opt out of the sale of their personal information, and they have a right to make a company delete any personal information that they have about a California consumer. Now, I'm often asked who is a California consumer. The law defines it by reference to the tax code, which is actually not the most precise definition of a California consumer or a California resident. As you might imagine, California is not eager to put a lot of limitations on who's subject to its taxes. So a California resident is someone who is within the state for more than a transitory or a passing purpose. It's not necessarily defined in terms of days or months or years. Also not defined in terms of IP address, physical address, mailing address, phone number, and things like that. Yes, that is a definition that has problems around it if you are a company in a digital or technology space. It's just one example of the way that the law is vague, really, and how broad it applies. There are 3 thresholds for the law to apply to a business. If you have gross revenue over $25 million, if you collect personal information from 50,000 or more California residents, or if 50% or more of your revenue comes from the sale of personal information. But it's not only those 3 thresholds, and those are 3 separate thresholds. If you meet one of them, you're subject to it. It also applies to companies that are co-branded with another company that is subject to the CCPA. So an affiliate, a DBA, a sister company. You might be smaller, you might not think the law applies to you, but if you have a larger parent or co-branded company, the law actually does apply to you. And that's because the law is focused on what California consumers see and think. So they're only going to see your brand, and they want to give California consumers rights with respect to that brand, as opposed to, do you necessarily meet those 3 thresholds? It also applies, and this is a unique fact, or a unique aspect of the law, it also has a business-to-business enforcement component. So if you are a company subject to the CCPA, you also have to require the third parties with which you share personal information to follow the use and deletion rules within the statute. So, and it's unclear if the Attorney General will start enforcing it against companies based on how they do or do not mandate their third parties to comply with the law. But as a best practice, you should make your third parties with who you share data comply if you are complying with it. Now, I mentioned the law is extremely broad. It is extremely broad in its definition of personal information. Personal information is any information capable of being associated with or that could reasonably be linked directly or indirectly with a particular individual or household. Household is not defined. Great news. But this definition, as you can tell from the way it's worded, it is very broad, it is vague. What it means to be capable of being associated with is not defined. Indirectly or directly linked is also not defined. And it's important to keep in mind that the statute does not limit itself to a personal identifier. So if you have a unique user ID, that's not the only way that the statute says information can be linked with somebody. Also, the statute is not limited to account holders. So it's not only personal information from your identified user base, people who have affirmatively agreed to your terms of service, signed up for an account with you. That's not the limit of people who have rights under the Act with respect to your business if you're subject to the CCPA. It really is intended to to encompass personal information even if companies don't necessarily know or intend to have it. So it requires companies, and our clients are seeing, they have to do kind of a data audit to see where are they getting personal information. Can they link that with somebody specifically? For example, if it could be linked with a cookie identifier or obviously phone number is easy, but perhaps unique browsing information, social media hashtag, but not necessarily someone who was one of your users that you affirmatively had sign up. They could still be people with rights with respect to you under the CCPA. Now, there's a non-exclusive list of what is personal information under the Act. And of course, all the traditional stuff is in there: names, email addresses, phone numbers, things like that, physical addresses. However, it also includes things like internet activity, information about how a consumer is interacting with your website or application. For example, the law specifically discusses instances where a consumer might be hovering over your advertisement or some link on your website for longer or long enough for that to give you some information about him or her. That's the kind of information the Act is intending to cover. It also applies to things like purchase history, not traditional PII elements and other statutory regimes. It also applies to inferences that may be created with personal information. And inferences are not defined. If they're used, I should say, inferences used to create a profile about a consumer. Probably what that means the law is getting at is if you collect information and are building a profile to try to guess what kind of targeted advertisements to sell about this consumer or to direct to this consumer, that kind of profile that you're building, even if it's not all specific pieces of information that the user provided to you, that would be considered personal information under the Act. It is the law right now as written, it does exclude personal information or publicly available information, but only if it's used for the same purpose as the entity that maintains the public information, which for most for-profit companies is never going to be the case. But there is an amendment right now that Jerry Brown is expected to sign that would just simply make publicly available information not subject.
Wait, don't you mean Gavin Newsom?
Yes, yeah, thank you. It would just
You're right here.
Thank you. Not subject to the CCPA. Thank you.
Do you have a Twitter address?
I don't.
Okay, I'll tweet it. Thanks. Sorry, guys.
So there are certain exclusions in the CCPA, de-identified or aggregated information, which a lot of advertising companies, that's the bread and butter. That is not subject to the CCPA. However, it is only not subject to the CCPA to the extent there are actual technical measures in place that prevent re-identification of de-identified information. Now, exactly what that means, again, is not defined. It will probably vary on a business-to-business level, but that does require some level of back-end engineering infrastructure to make sure that it's more than really just having a hashed ID or a scrubbed data set. You have to actually have something in place that will really make it very difficult for someone to get in there and put that information back to be identified with somebody, with a particular individual. The law also excludes the collection and sale of personal information if it occurs entirely outside of California. However, if you have personal information about a California resident that you collect about them while they're in Minnesota, but you store it while you're within the state, then that is subject to the statute as well. So not an exception with a whole lot of meat for California-based companies. Now I'm going to get into some of the specific requirements, and I'm probably going to go a little quickly just in the interest of time. If you have any questions afterwards, feel free to ask me. So the first requirement is a company has to disclose personal information that it has collected about a consumer in response to a verified consumer request. Now, remember I mentioned that statute is not limited to your account holders, but if you collect personal information about a California resident, and after January 1st of 2020, he or she asks you, give me all the personal information you have about me, you are required to provide that. It's specifically the personal information that you collected or sold or disclosed about that person, the sources from which you received that personal information, the purpose for collecting it or selling it, the categories of third parties that you provided it to, and a specific set of personal information actually about that consumer. Now, you're only supposed to provide this in response to a verified request, which is not defined in the statute, but people expect and hope that Javier Becerra will pass a rule or regulation giving some guidance on what it means to verify a consumer request. Because again, the statute is not limited to your account holders. There is an amendment right now that is expected to be signed that would, it basically says the way that you verify a consumer request can be consistent with the context of your relationship with the user or the consumer. So if you're not collecting email addresses, you're not collecting phone numbers, but you are collecting maybe how many times they followed you on Instagram, or the ads that they've clicked on, or maybe just their purchase history, but you don't have, well, I suppose purchase history would have usually email addresses as well. But you could require a consumer, for example, like Rebecca Guyon, I might need to give you some information about the ads I've clicked on from you so that you can really have security that you're not turning over my personal information to some random third party without really having some safeguards in place. That will be tricky to navigate, and it's going to be variable from business to business on what that looks like, but a consumer does have this right under the CCPA. As I mentioned, it applies to all the information collected within the last 12 months. You have 45 days to respond. You have to produce it in a portable format, which generally means for most consumers, you will not be able to give them a data dump from MySQL. They'll need to have something they can take with them and do something with it if they want to. There is an exclusion if you truly only had a one-time transaction with the consumer, as long as you're not using their information to re-identify other pieces of information that you've collected about them. Again, or as long as you're not selling the information. Again, an exclusion without a whole lot of meat on it. Next, the consumer has a right to request deletion of any personal information that you have collected from them. And again, this component does have a business-to-business enforcement aspect. So if you have third parties with whom you're sharing personal information, one of your users says, hey, delete everything, you have to require your third parties to delete that as well. There are certain exceptions if you need it to maintain an ongoing business relationship, which from a practical standpoint, a lot of users are not going to be able, if you're a content kind of service, they won't be able to continue receiving your services without some personal information that you maintain about them. You're also able to keep it if it's purely for an internal purpose, but only if that's consistent with consumer expectations. And you're also able to keep it if it's necessary to prevent against security instances, fraud, or of course to comply with law. I recommend as a best practice, if you're going to retain personal information, notwithstanding a deletion request, you should disclose that to the user. Obviously, if someone is no longer going to be able to use your services or access your content because they want all of their data deleted, you should tell your customers that as well, from a business standpoint, as well as to help set their expectations, which is a lot of what this law is paying attention to. The CCPA gives consumers a right to opt out of the sale of their personal information, and conversely, a company is not allowed to sell personal information unless it has first notified consumers that their personal information will be sold. You cannot request a user to opt back in for 1 year, and if you have minors in your user base, you really need to know about that. I'm sure you all are aware of that for many other laws in place, but for the CCPA, you are not allowed to sell any personal information about minors unless they have expressly opted in. So if you have content, lots of followers on social media who are under the age of 18, they are not allowed to have their personal information sold unless they have opted into that with you specifically. I'm only going to touch on this briefly in the interest of time, but it is it's a nuanced and important kind of requirement. So the CCPA, you have all these requirements now, what you can and cannot do with personal information. Users have all these rights. They can opt out. They have a right to request disclosure and deletion. You as a business are not allowed to discriminate amongst your users based on, did Rebecca Guyon opt out of the sale of her personal information or did she not? Now, again, what that will look like on a business basis is going to vary a lot from one business to another. What I generally recommend, if you're subject to the CCPA, you should have a baseline for California users of services and content that everybody gets. If they provide more than that, then the law allows you to provide some enhanced services that are equivalent to the value of consumer information that you're getting. But you'll need to notify people. Hey, if you give us more content, for example, give us your email addresses, this will open up some more material on our platform or allow you to have more services, access to more content of whatever means it might be. That's allowed under the statute. But you can't discriminate on a baseline level amongst people who say, I don't want you to be able to sell my personal information. Obviously, in the case of deletion, as I said before, you'll need to have an upfront disclosure if no one can use their services or use your services because they want to have all of their personal information deleted. So let's see, just a couple more to go over quickly. This is where there are required consumer notices under the CCPA. This has to be on the front end. There's, the back end component we talked about de-identification. But this really has to be up front and center for all California consumers. First, before personal information is collected, California residents have a right to know what information is being collected and for what purpose. And a company cannot use it for a different purpose unless that has also been disclosed. Also, there is a specific link. It literally is that language that I have there, do not sell my personal information, that has to be placed on all web pages or other location where personal information is collected that notifies California residents of their right to opt out of the sale of their information. And lastly, this is similar to the GDPR, but it is a California-specific requirement. If you have California residents and are subject to CCPA, you have to have a California-specific privacy policy that discloses all of their rights and opportunities to opt out and right to deletion under the statute. Last, you have to have customer service representatives who are trained and knowledgeable in the CCPA, able to respond to consumer requests under the Act. I'll just quickly go over this because I know I'm just about out of time. Good news in all of this, there is not a private, in lawyers' language, there's no private right of action, which means consumers can't sue you personally for not following the CCPA. Hopefully that's a big relief for most of you. The California Attorney General can bring enforcement actions. He has to first provide an opportunity to cure. So with the new statute with a lot of vagueness in it, there should be a little light at the end of the tunnel with that knowledge. Civil penalties are in place, but they're not as extreme as we've seen under other statutes. However, it is up to $7,500 for a violation for willfulness. There is a separate action, or well, in the interest of time, I'll just close on this. The enforcement actions are not going to begin until 6 months after January 1st of 2020, or Javier Becerra implements regulations he's allowed to put in place under the Act. It's the earlier of those two, but that means there is still time to get up to speed if you're not quite there yet. And that's all I have for this evening, so thank you very much.
Thank you, Rebecca. So Robert, if you could join us up front too. You guys are going to split that. Oh, okay. So Rebecca, I have just a couple of questions for you about the CCPA. I'm curious about how the CCPA relates to something like lookalike audiences in Facebook ads, where I'm uploading a list.
Yeah.
Yeah.
It relates in a lot of ways. I think depending on where you are in that transaction, if you're the person who is uploading the lookalike audience and you're subject to the CCPA, potentially all the information you have on there is information that is probably, as I mentioned, the kind of thing that the Act considers an inference. So if one of your users who's on that list sends you a verified consumer request, probably you would have to disclose to him or her, we put you in this kind of consumer profile, lookalike audience, because we think people with your demographics, whatever it might be, want to buy our shoes or something like that. You know, it's an interesting question, assuming that the lookalike audience is hashed, whether it would be a disclosure to the third party of who you're matching the audience with. So I think, you know, depending on how you do that, there could be a question of if you have to also disclose, hey, I gave this lookalike audience to whatever social media advertising platform it might be out there. But yeah, potentially applies in a lot of ways depending on your role in the transaction.
Can we count on platforms like Facebook or any of the other major social ad platforms to cover CCPA for us?
Well, I'm not sure what you mean. Can you say what you mean by cover?
Let's just say,
Abide by it.
yeah. Let's say I upload a huge list, an email list, right? That I've legitimately collected. Let's assume at this point it's all clean. But I've now uploaded this list. I'm now technically an affiliate of Facebook by doing so, I imagine. And am I, if I'm not already covered under CCPA, am I by doing that now covered under it, and can I rely on Facebook to be the disclosure, do the disclosure that is perhaps necessary if someone decides that they want to be forgotten?
Okay, so good question. If you're not otherwise subject to the CCPA and you are in the business of uploading lookalike audiences with whoever a business partner might be who is subject to the CCPA, if you are providing personal information in that one-way transaction, providing it does not necessarily make you subject to the CCPA. Of course, it's going to depend on the nature of the transaction. If Facebook gives back to you a lot of personal information, then you could become a third party that Facebook has to disclose and mandate some requirements on under the Act. But it's going to, again, depend on the nature of the transaction. I think there is also an amendment right now that, depending on your business model, if the law calls it a data broker. If you're not somebody who is directly user-facing, but you collect and monetize personal information. So again, the law is not limited to people who have accounts, but you know there are plenty of ad agencies, and some of you may work for them, where you collect personal information across the internet or different social media platforms. If you're otherwise not subject to the CCP under the 3 thresholds that I outlined, there is an amendment pending that would require you to register as what's called a data broker, and that will be a publicly available list of all companies that collect and sell personal information, and it'll be posted by the California Attorney General.
I'm just going to remind you guys, we're going to do Q&A. I promise you we'll get to your questions. I have one other question for you. In digital marketing, the term affiliate is probably very different than what it is legally.
Yeah.
So, but there's some gray area in the description that you provided for us. So can you define affiliate from the context of CCPA, to the best of your knowledge, for this?
Sure. So affiliate is not necessarily a catchword under the CCPA. Like I mentioned, what the Act is going to look at is if you are co-branded with a company that is subject to the CCPA. And co-branding can be somebody with a formal business relationship. I think if you're also in a franchise and you are co-branded with a very large parent, or I guess a franchisor that's subject to the CCPA, a best practice would be to see what you need to do under the CCPA to comply. The other, I guess, aspect is not exactly an affiliate, but if you are a service provider for a company that's under the CCPA, you will probably start to see those companies have, or you should start to see those companies have contractually mandated that you require with certain aspects of the CCPA, specifically the use and deletion requirements. They'll also probably put prohibitions on the way that you use information that you're receiving from a company that's subject to the CCPA. Those, generally, the obligations flow kind of, whoever has the personal information and is sharing it is required to make sure that it's used in accordance with the CCPA if you're subject to it. So if you're receiving personal information from a company that's subject to the CCPA, that company will probably make you comply.
Okay. I'm going to shift gears just a little bit, and this is sort of a transitory question because I think it might apply to both of your experiences. So my question for you is, if a brand shares, this is a little bit more about influencer or UGC type marketing. If a brand shares a post of yours without asking you first, is it a privacy violation and is it a copyright violation?
It's almost definitely a copyright violation. Whatever a user posts onto Instagram, you own the copyright in any media that you've created. If you're the original person who creates it, you have the copyright, regardless of whether you've registered it, which is a separate issue. So if somebody just takes and reposts your image, and it doesn't have to be a company that does that. If anybody who reposts anything you've ever uploaded to Instagram is violating your copyright. That doesn't mean that they can go after you for money, but it is a violation of the law. Violating somebody's privacy right, probably not, because you put it on Instagram in the first place, which is a public platform, and by doing so, you've at least granted Instagram a license to reuse it in whatever way they want to, if they want to. So if Instagram wants to use your picture for their marketing, which I suppose sometimes happens, you've agreed to let them do that as part of their terms of service. But if a company just takes a picture that you've shared anyway and your account's not private, I guess that could in some way give you a better argument, but the act of uploading something to Instagram in the first place pretty much gets rid of your privacy claim.
Do you have anything else to add to that, Rebecca?
Yeah, I mean, I think invasion of privacy has some nuances, and I think, I completely agree with what Rob said. I think, not that I expect anybody, as a litigator, I have seen crazy instances. I would recommend against, if your friend has her account set to private, maybe they DM you a picture of their kid, you take a screenshot of it, you share that, that's a different context. Similarly, I think if there's a privacy setting on the account, and a brand reposts from that account, unless that person, authorized the brand to be one of their followers, then you probably have at least questions around that. So I would cancel against it. But it's the privacy is a very context-specific question, absent, being a completely public account on Instagram where you agree that your content is no longer yours after you upload it.
In that same circumstance, does it matter if the post from the brand perspective is just organic or advertising? Does the law make a distinction between organic content and advertising content?
I mean, I think for a copyright or a privacy claim, if you are making money off of somebody's content, you are more likely to be in trouble. So probably if it's advertising, the more likely it's advertising, the more likely you have a problem. But Rob.
I thought of an issue that you might be getting at a little bit is Reddit publicity is sort of related to privacy. If you take anyone's likeness, which means their picture or their signature in some cases, or some depiction of them, and use that in connection with any commercial purpose. So if you're like a small swimsuit brand on Instagram and you're going to influencer models' pictures, and maybe you see them wearing a similar bathing suit or whatever, and you post one of their pictures, this happens a lot, and people will just tag the model in it and think that's okay. But it's not, because you're reusing their picture for the purpose of driving a sale. And in California, there's an extremely consumer-friendly law that protects people from that. You don't have to be famous. It could be if anybody uses your picture to sell something. There's a guaranteed minimum penalty of $750. It goes up from there if you can prove what the value of your face is worth. There's a case where some company used Dustin Hoffman's picture to promote something, and they had to pay $1.5 million because of that. Just one picture. But it's a sort of unique statute in California because you also get your attorney's fees if you have to sue someone over it. So, and that's pretty rare. So you're guaranteed $750, and if somebody doesn't want to cough that up immediately, you'll get more than that, and your attorney paid for it. So using other people's pictures to sell something is a huge no-no in California. and a big opportunity for lawyers to make money if people want to do something about it.
I'm going to ask you one more question, then we are going to open it up to the audience. So along those same lines, and I think this sort of crosses into privacy and copyright and maybe even fair use to some degree. What about gifts, right? So you're a brand, I'm ABC Company, and there's a well-known GIF out there, and I share it on my page, but that GIF happens to have Brad Pitt's face. Am I risking, think about it from the social media manager's perspective for just a minute. All this content is flying around all the time, everybody loves it, I need to create some excitement on my page. I share it. I haven't run it through anybody with a law degree.
Yeah,
What
that's
happens?
potentially a big problem. There's a couple of issues there. If you didn't create the GIF yourself, then it's a copyright violation, and whoever made it and is paying attention could give you some trouble for that. Definitely using Brad Pitt's face, that's like the Dustin Hoffman situation. You're just asking for trouble. And people have gotten in hot water just tweeting at celebrities without being asked to. Like if Wendy's tweets at some, I can't remember who it was, it might have been Pharrell that got involved with this.
Arby's?
Right, yeah. That's using their likeness, and people will think, oh, Pharrell's connected with Arby's, and so that's how you get into the right of publicity issue. So the GIF
wow.
situation is definitely problematic for a bunch of reasons.
Rebecca, do you have anything else to add?
No, yeah, I agree with that. I think you're the same problems, and yeah, I don't recommend it.
All right, we're opening up to audience questions. I know you had a question, right?
So just on the aspect of social media accounts collecting their data, how do you put the stipulation for the CCPA? Where do you put that on like Facebook and Instagram so that people know that they can report and then contact accordingly?
So you are on Facebook or Instagram, is that right? And you're like marketing on there, is that right? You can do it in different ways. You're probably going to want to have something on, so remember the disclosure has to go if you're collecting personal information at that location. So it's going to depend on your business model. If someone who clicks on, for example, on Instagram, someone who starts following your account, you probably want to have a disclosure embedded somewhere where they'll see, that their personal information will start to be collected, and then you can put the link there. I think on Instagram, it's been a while since I followed somebody new, but I think it usually takes you to their page. So you could have that kind of a little description underneath the photo about that right. On Facebook it's probably easier to put that link in a number of different places or even in the post itself.
If it goes to a website and the claim is there, is that okay?
Better, and I think consistent with what Rob said, if you are collecting personal information before the website, you should have the link before the website.
And I guess is Instagram and Facebook, is that considered collecting personal data because they're following you or liking you? You have their username. Is that personal data that you technically should disclose that you have?
If it's information that, if once someone clicks on you, if you are starting to collect information, it probably is. The law is intended to be broad. You get their user information, you get the fact that they follow, whatever brand it is. That's information associated with the California consumer.
I'm interested to hear from both of you at an elevated level. Hearing about this CCPA seems like a draconian knee-jerk reaction to Cambridge Analytica. Is this sort of, a posturing at the state level to try to force national compliance? Do you think Silicon Valley is able to somehow weaken state consumer law and preempt this thing before it comes out? And I know you don't know the answer, but I'm interested in your opinion on it.
So other states are looking at passing laws similar to the CCPA. From a high level, in the legal world, that causes a lot of concern because it's very difficult for companies to have a patchwork of legal regimes that are varying. Not only now you have European users, but if it's California versus New York versus, Florida or Illinois, I mean, that's going to make compliance very difficult. There was a hope that Congress would pass a federal privacy regime that would preempt the CCPA, and there wasn't a bill actually proposed, but I think we've all seen Congress has gotten very busy with other things this past year. And as much as, I think consumer privacy is a very important issue, there's been other more pressing issues. To the question of if the law could be changed by businesses within the state, there was a lot of lobbying to change the law in the past legislative session, but it didn't change it very drastically. So I don't know if it's a response to Cambridge Analytica as much as, people are realizing that the information online is just, there's so much information that is collected online and sold, and people want to have more knowledge about that.
I think that's about as expert an answer as you could give, so I'm not going to add anything.
Okay, I got two questions, one for each of you. So starting with Robert, since he was first. So I do social media posts for a radio show about food, and we get invited a lot to media events, press events, that PR people or people put on, or the restaurant puts on themselves. We go there, we get dinner, we post pictures, no money changes hands whatsoever, never has. But at that point, are these posts considered ads or not ads?
So what's the nature of the post? What kind of?
So basically, let's say, for example, I'll give you an example. Like 2 weeks ago, I was in downtown LA for a dinner that the restaurant put on to promote their new menu. We were comped, again, no money changing hands whatsoever. So we basically posted the meal. We basically said, like, here's what we had, here's the Spam fries and the barbecue pork shoulder and the drinks we had, blah, blah, blah. And a series of posts, like 5 or 6 posts. That was it. So at that point, do we put the ad hashtag in there or something else? Is it sponsored content?
That could technically be something where you need to disclose that you got the meal for free, but you can do it in a way that's not. You don't need hashtag ad necessarily. You can just say thanks for treating us.
Yeah.
Something where
we do
it's
say sometimes media reception.
Sure, I think that would be good enough. And
Okay.
that's the kind of thing where realistically the FTC is not going to care about. Well, I'm not going to say what they will and won't care about, but
Well,
it's
that's the
very
thing, it's so
unlikely.
gray.
It's very unlikely they would care about the fact that you got a free meal and are just posting the meal and not saying this is the greatest meal in the world.
No, we're
You
not
have
saying
to-
that at all.
Right, that sort of thing.
No.
So you don't have
Unless
to.
it really is.
Right, and if it is, then it's true. Then that's okay.
Yeah.
But you should still, in that case, you want to be a little bit more clear. But something like thanks for treating us.
Right. And as for Rebecca, as a web developer myself, we had to go through the whole situation of privacy 2 years ago with the GDPR, and that was crazy. What is the difference between the GDPR and the CCPA? Is there anything that we need to do that hasn't been done in GDPR?
Yeah, I mean, it's different.
How different?
I don't have time to go over it all. I think as a best practice, I mean, you've probably already started because you've already done some of the identification of where you have personal information.
Yeah.
And, able to track that and respond when, you're contacted and things like that. It's simply different. The definition of personal information is different. Back-end requirements about de-identification, those are different. The specific disclosures that you have to have that are available to California residents, that's different.
So redo the privacy policy, basically.
Among other things,
Among other
yes.
things. I'm just gonna
Yeah, you definitely have to have a California-specific privacy policy.
So claims are a big hot topic for us. We work in the beverage industry. So we see a lot of brands talk about vegetables or fruits and say, okay, this strawberry has XYZ benefits. You can find strawberries in our juice. But our legal team is saying that we can't do that because we have to have the measurement of the strawberry in the juice, and it's a large thing. So we right now aren't talking about benefits at all, besides this juice is red.
Yeah, I understand where your legal team is coming from because it's such a hot area in California for consumer class actions about claims in food and beverage. So one of the more recent examples was, I think it was Cheez-It said whole wheat Cheez-It. They didn't explain how much of it was actually made of whole wheat. And it was, I don't remember if it was a settlement or a judgment, but it was in the multiple millions of dollars for that kind of claim. And so the issue of claiming any kind of health benefit, you can get into FDA rules about structure function claims. You're not allowed to say anything treats any kind of disease unless it's a drug, which a beverage would not be. But brands screw that up all the time. CBD is a huge example of that right now.
Oh, yeah.
Brands want to say CBD cures everything under the sun. All of that is wildly illegal to say, and they're just asking for lawsuits. So if you say, made with strawberries, it needs to be made with some piece of actual strawberry, not just strawberry flavoring. There was something with, I can't remember if it was chocolate or honey or something, or it was coffee. It said hazelnut, and there was some lawsuit over whether there's actual hazelnut or if it's just the flavoring. And even if you haven't done anything wrong, getting out of that can cost you $1 million maybe, just to make it go away, or just in legal fees. So the idea of just saying, keeping it to here's what's in it, tastes great, that kind of thing works. But saying why it's good for you can get you into hot water pretty quickly. So I don't know if that answered your question, but that's where your legal team's coming from anyway.
I guess is there like what can you say? Like, the benefits are in the strawberry and the strawberries in our juice, or
Well, you could do that if you were really careful about what science has shown strawberry can benefit you for. And that can make an ad pretty boring. And it might take a lot of R&D and like clearance through legal to make sure that you're not overextending about what kind of claim it can make and that sort of thing. But generally, just you can say things like being more vague is better, like fruit's good for you, or get a serving of fruit if that's true, that kind of thing. But when people want to say, it improves your memory or anything that even implies it treats a disease, like anti-aging is a big way to get in trouble, or improves brain function, that kind of thing. Because people might think, oh, that'll help my Alzheimer's. And that's an FDA violation to say that something treats Alzheimer's if it's not a drug. So your legal team is right that just keeping it to, tastes great or some like colorful aspect of it, even though you want to say like strawberries are good for you, you should drink this, it very quickly can get you, because there's an entire army of plaintiffs lawyers out there that are just waiting for somebody to say like, this strawberry thing, can I sue about this? And they will if you give them like any arguable room to do it.
We have another question.
Yeah, so this just happened last week. A public figure tweets something, deletes it relatively quick after it surfaces. As a content creator, I take that tweet and I repurpose it. They reach out, tell me to delete it, although they already tweeted it. Do I keep it up? Do I have the right to? Should I take it down just for safe measures and due diligence?
I would suggest that you take it down. Twitter is unique in that on Instagram, reposting anything is a copyright violation. Twitter specifically says that by tweeting something, you allow every other Twitter user to share it. But that's on Twitter only. If you took that tweet and embedded it in a website or reposted it on a blog or something, you've got a copyright violation for sure. The fact that this person took it down and doesn't want you to share it, it's sort of a judgment call. I would say it's probably not worth it depending on who this person is. Maybe see how far they've gone with other people in the past if they have. See if they've sued anybody before is something I would do. But the lawyer's always going to tell you the safest option is if somebody doesn't want you to do it, then you probably shouldn't do it. But without saying...
Okay, one more question, and then we're going to wrap it up. And then I know Rebecca and Robert, maybe you'll stay for just a few extra minutes in case anybody has some other questions to ask you. One more.
Just the tiniest clarity. We're talking about reposting things and not being okay. What if you were tagged? What if the brand was tagged? Say in this situation, they tagged the brand and then they took it down.
So, like an individual tagged a brand in a post?
The individual tags the brand, or an influencer tags a brand, for instance. How much am I as a brand allowed to use what was tagged?
Oh, I see. If you just leave the tag up there and don't do anything with it, then you're probably not, whatever they said is you're not going to be liable for it, probably. If you retweet it or repost something that somebody tagged you in, then you're adopting whatever they're saying in it. So if somebody tags your strawberry drink in it and says, this cured my back pain or something like that, and you retweet, well, I mean, this like really happens. People do this and get in trouble for it. If you were to do that, then suddenly you're making claims about treating back disease and things like that. So that's where the risk is.
Jimmy?
No, that's perfect.
Okay, everybody, that wraps up the panel for tonight. Thank you to Robert and Rebecca very, very much. Can you imagine what kind of skill it takes to do a 15-minute prezo after 4+ years of law school, and then to sit and to give you 30-second answers on cases that they've litigated over the course of a couple of years? So thank you very much to both of you for condensing this incredible information. Our next social media club event is October 28th. Again, it will be at Blank Spaces. It's just down the street, so there's no excuse for you not to make it. We are going to be talking about social media video. It's going to be a little easier for all of us who haven't gone to law school to wrap our brains around.
Yeah, really.
And we hope to see you all there. So thanks again for coming. Robert and Rebecca, if you guys can hang out for just a few more minutes, I'd be really appreciative. Thank you.